Members of Parliament, support staff, radio listeners, TV viewers, all persons following this meeting via social media, members of the media who are tuned in, ladies and gentlemen, good afternoon. I welcome you to this public meeting for today, Wednesday, March 12th. This is public meeting number 13. At this time, I want to give a special welcome to the Honorable Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes Jr. and his support staff. We have established a quorum of 11 members. I invite you to stand for a moment of silence. Thank you. I don't have any notices of absence or lateness. Is there the need for notifications from the floor? I don't see this being the case, so we can continue with the agenda point for this public meeting, and that is deliberations with the Minister of Public Housing, Spatial Planning, Environment and Infrastructure regarding the delayed publication of building permits and ensuring legal compliance and procedural clarity. This request, the request for this meeting, is registered on the IS 654 and it's dated February 24th, 2025. Just a brief reminder that the chairperson, myself, may permit interruptions, and of course the lectern that is there is for the use of such. Going over to the agenda point, as I mentioned, on February the 24th, Parliament received a letter from MP Duran, York, and Irian with a request that an urgent public meeting of Parliament be convened to discuss the above-mentioned agenda point. The presence of the Minister of Romi was also requested. Hence, this meeting this afternoon. I look to the floor to see if the requesters of the meeting would like to elucidate their request. I don't see that being the case at this time, but before I give the floor to the minister, I think it's important also for the general public for me to provide some context with respect to a matter that has been very much in the news and on the mind of persons on St. Martin, the public of St. Martin, and which was highlighted by several MPs earlier this morning, and that is the issue of the budget 2025. Allow me to, as I mentioned, provide some context with respect to this issue, as well as give the general viewing public some information in addition to what has been stated. Before doing so, however, I need to remind everyone of at least two parts of the role of the President of Parliament, and that is to represent the entire Parliament for one, and I am responsible for the execution of decisions of Parliament. The budget and its amendments were decisions taken by Parliament. On the 17th of January of this year, as we all know, the budget was approved with 7 amendments, 3 from the side of government and 4 from members of Parliament based on their right to amendment. And indeed, this right from both sides, from the government as well as from Parliament, is based on an article that we have often heard referred to, and that is Article 86 of the Constitution of St. Martin. Other than it has been proposed by some, this Article 86 regulates the fact that before a national ordinance is passed, government and members of parliament can seek amendments of any ordinance. Subsequently to the approval of the draft budget and the amendments as presented, government was informed of the approval of the budget. Once this happens, not only for the budget, but for ordinances in general, especially those that also are accompanied by amendments, government needs to consolidate the ordinance itself and any amendments. In other words, putting it all together to come to one draft ordinance. The final text of the approved ordinance is then sent to the Secretary General of Parliament to corroborate, I can use that word, the so-called final text, the end text. So in other words, the government then sends what they have put together as the final text of an ordinance would send to our Secretary General to make sure and ask, actually, is this everything that Parliament has decided on in the context of the ordinance? The President of Parliament, based on the nod or not from our Secretary General, would then inform the government, yes, this corresponds with what Parliament has decided. On the 11th of February, we received a letter from the Prime Minister of St. Martin indicating that based on, and now I add in at least 2 amendments, there were some technical issues that needed to be resolved. On that same day of February the 11th, we received a letter, I as President of Parliament, a letter from MP Duran, and my response dated February the 17th explaining the so-called end text procedure, as well as sharing that letter of February the 11th of the Prime Minister. On February the 13th, I received a letter with questions to the Prime Minister and Minister of Finance from the NA faction, and this, as is required, I cannot answer for the government, so questions from members of Parliament are sent via the chair to the respective ministers, and that was done by letter of February the 18th. On February the 21st, a letter with questions to ministers from the NA faction was received, and this again was sent to the ministers by letter of February the 26th. I just want to remind everyone that based on the rules of order, the ministers who receive questions from members of Parliament are informed that we expect to receive answers within a period of 3 weeks. And if the questions cannot be answered, then at least those that can be answered would be sent, and we will be informed of the ones that will be answered subsequently. On February the 27th, a request was received by 6 members of Parliament for a public meeting on the budget 2025. On March the 4th, the Parliament of St. Martin received a letter from the Prime Minister and the Minister of Finance regarding the budget. And in that letter, it was mentioned that there were technical issues concerning the 7 amendments that were approved by the Parliament of St. Martin. And in that letter, the government, so the Prime Minister and the Minister of Finance, informed the Parliament of St. Martin, informed the President of Parliament regarding their proposal to deal with these technical issues. In fact, in that letter of March 4, the government included what they consider the final text, so in other words, with all of the amendments incorporated in the draft budget, in the budget that was approved by Parliament. The government in its letter also, and I think this is what was used to ask about the whose authority it is to determine what the end text of the budget should be. As I mentioned, the reason for reference to the Secretary General of Parliament in this letter of the Prime Minister and the Minister of Finance is because usually collaboration on the final text, the end text, is between the administration of the government and the Secretary General of Parliament, who, as I mentioned, would then indicate whether, yes, in accordance with the information here in Parliament, amendments, etc., the final text can be, the final text is indeed the correct final text. In the government's letter of March 4th, they indicated that if in consultation with the Secretary General, it is determined that indeed the proposed processing methods are not substantive changes, then the end text as presented should be, is outlined in Annex 1. The government also refers to the possibility, another matter that has received a lot of attention is the so-called novella. And I have heard mention of the fact that this is not possible in our Constitution and in our constitutional order, and and St. Martin is attempting to do something that is not possible. What it actually would entail in the case of St. Martin is that rather than propose a final text like we have also received from the government, that the technical or not issues in the amendments be addressed in a corrective amendment to be proposed by the government before the budget itself is ratified, and that together then these would then complement each other, and when that is approved by Parliament, if that is the route that will be followed, then we will have the ratification of both these documents. So, as I mentioned, the government presented an end text as well as indicating how they would solve the technical issues. And just for completeness' sake, on March 5th now, the following day, I received a letter from the NA faction, and in other words, saying that what had transpired was unacceptable. Reference is also made to the role of the chair of Parliament, etc., which I explained earlier. And within short, the government will receive a response with respect to what they sent us on the 4th of March, IS number 666, and members of Parliament, of course, will be informed of that final, not a final, but that letter that would be sent to the government in response to their communication of March 4th. So I just wanted to kind of give context, as I mentioned earlier, to that matter before we continue on with this particular meeting. And I was just at the point before I did that I am being informed that MP Irian is, and I asked requesting what at this time? MP Irian, I see, note, in fact, I see you here on the screen.
Good afternoon, MP Westcott and here colleagues, Minister. Just a question based on what you said, because the Minister today in the press briefing said that she's awaiting Parliament's response on the letter that you mentioned. That's a week at least now or more. So what exactly is she waiting from us? And the second thing is the Minister said in her press briefing today was that based on legal advice, there's different options.
Irian?
So what are the legal advice and why wasn't it sent to Parliament?
MP Irian, first of all, I allowed you to ask the question, but actually it has no place here. I was just giving context because the matter of the budget has come up, and not only that, the role of the President of Parliament. So I explained that, but I cannot go into your questions that you're asking about the Minister. You and some of your other colleagues have several questions that you have posed to the government, and they have been sent to the government, as I also mentioned in my elucidation. So thank you for your comments that I allow you to make, and I will now continue to give the floor to the Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes Jr. for his opening remarks. I see the minister does have a presentation. So, Minister, to you the floor.
Good afternoon. Good afternoon, Madam Chair, members of Parliament, those listening online or as well in the Tribune. I'm joined today by my delegation consisting of the Secretary General of the Ministry from me, Mr. Kenston Plezimoon, my Chief of Staff, Mr. Luciano Nichols, the Acting Head of Department of Permits, Ms. Malika York, as well as my legal advisor, Mr. Theodorus Snyders. Also within the Tribune listening online, we have members from the Permit Department, Ms. Timothy Bailey, as well as Policy Department, Ms. Raisa Narayan, who are all listening remotely. Madam Chair, we've been called today to discuss the topic of the delayed publishing of permits and the procedure and clarity going forward. So with that, I'd like to dive right into the presentation, which we have prepared for this House today. I'd like to first start, I think it's very important to start with this quote, accountability is not just about taking the blame when things go wrong, but also about taking action when things go right. And this is why when upon being posed a question related to the delay in publication, the first thing I said to the media was we'll have to investigate. When we investigated and found what the cause of the reasons, I explained it's an administrative error, but as the leader of a ministry, I take full accountability in how we go forward. The team and I have structured this presentation with a very small and short agenda. One, and I think it's very important that we do it this way, we have a list of definitions that we should go through. Why? Because over the past couple of months, what you've realized is a lot of unclarity as to what type of permits there are, how permits work, the process of permits, and over the last couple of weeks, I've been getting a lot of requests to also revoke certain permits, and I think it's very important to clarify what is legally possible, what is legally impossible, as well as the discretionary power of a minister to actually approve and or deny a permit. Those things are very important in terms of establishing good governance, and that's why it's in the agenda, and I asked your indulgence to begin the presentation with these definitions. Agenda point number 2 is previous permits, so the meat of this meeting, what actually happened. We explained it briefly in the media, and we'll go over it again this afternoon. We'll also, the third agenda point, go through challenges and recommendations issued to the ministry over the couple of years, challenges that have now snowballed into things of what we're seeing currently. And then finally, a proposed way forward, because with all accountability, admitting it is one thing if you choose to admit it. It's also very important accountability to make it better. And I think that's going to wrap our presentation. So without further ado, Madam Chair, I'll begin. And I again apologize. The first agenda point definitions will be quite lengthy, but I think it's very important and valuable information to set the tone as to how things work within the ministry and beyond extension, the government of St. Martin. So definitions first of what is residential, what is commercial, and what is mixed use. Clarifications on civil works permits. I think this is very important because it's something that I've been speaking about since I became minister. Thirdly, the grounds for denying a permit. And finally, defining official dates for permit issuance and publication. Residential developments and permits are defined as properties consisting solely of living units that are not operated as commercial entities.
Minister Gomes, if you just allow me, I see that MP Doran has requested the floor. I'll firstly ask him what his request for the floor is about.
Thank you, Madam Chair. It's just a request for clarifications because a couple hours ago when the Minister of TIAT was here, it was said that there was no presentation requested. Now we're going into a presentation without going into the meeting. So just a point of clarity for my understanding. Thank you.
You know, MP Duran, the only interruption you can make from your seat is actually, and requesting the floor would be for a proposal of order that would have to do with the topic at hand. That is not what you are requesting. But if the minister would want to respond, I would allow him to do so in terms of, Minister, your presentation, and if you want to respond as to why you thought it necessary to start out this meeting with a presentation, you could, but it's up to you.
Yeah, no, I think I'll answer, no problem. I think I elucidated very clearly in the beginning that noting all the different discrepancies regarding what is allowed, what is a permit, what a civil works permit, is very important to clarify that as well. So this is why we chose the presentation.
Thank you, Minister.
I'll continue. Residential developments, the first definition, are defined as properties consisting solely of living units that are not operated as commercial entities. This category encompasses both single-family homes and multi-unit buildings, such as apartment complexes and condominiums. It is important to clarify that while the term residential is often assumed to refer exclusively to single-family homes, it actually includes any structure designed primarily for living purposes. This creates a notable divergence from banking sector classifications, which typically categorize any development with 4 or more units as commercial for mortgage purposes. From the ministry's perspective, however, a development comprising 20 housing units remains residential in nature as long as the units function as privately owned residences rather than commercial accommodations. Commercial developments are characterized as properties that operate for profit, provide goods or services, and are not primarily used as private residences. This classification encompasses a wide range of structures, including hotels, shopping centers, restaurants, office buildings, and advertising billboards. I think that's very important, advertising billboards. Hotels, for instance, automatically fall under commercial classification due to their function of providing paid temporary lodging rather than permanent private residences. Similarly, billboards and advertisements must be categorized as commercial installations and require specific additional details in permit publications, including precise dimensions, lighting, and whether they utilize digital or traditional display technology. The key distinguishing factor is the profit-oriented, service-providing nature of these structures. Mixed-use developments incorporates both residential and commercial elements within the same property, creating a hybrid classification that reflects their multifunctional nature. This designation applies to projects such as residential buildings that include retail spaces, office components, or hotel facilities. The ministry faces the ongoing challenge of clearly defining the threshold at which a project transitions from purely residential to mixed use, particularly in cases involving minimal commercial elements. For example, a multi-story building with 120 residential units, but featuring a single ground floor restaurant would be classified as mixed use, rather than purely residential or commercial, reflecting its dual purpose character despite the predominance of residential space. And finally, on the type of building, the condo hotel. Condo hotels represent a particularly challenging classification that exists between conventional residential condominiums and traditional hotel operations. These properties often involve developers marketing residential units as investment properties that function operationally like hotels through rental programs. This arrangement raises significant concerns regarding whether such properties should be classified as commercial, given that they are not exclusively used as permanent residences. The proposed solution to this ambiguity is to classify condo hotels as commercial developments to prevent potential loopholes where large-scale hospitality developments might attempt to bypass zoning regulations. designed for commercial properties by adopting a residential designation that does not accurately reflect their actual usage and operational character. Moving on, clarification on civil works permits. The Landsverordnung, amending the Spatial Development Planning Ordinance, reintroduces Article 28A. This has been in full effect since March 2021. This means that the legal requirement for obtaining prior written consent, commonly known as a civil works permit, for civil works in areas without a development plan or preparatory decision has been valid and should always be correctly applied since that date. As stipulated in Article 28A, written consent is required before carrying out major civil works, including excavation, leveling, road construction, demolition, and tree removal. The aim is to protect future land use and ensure proper spatial planning. The Minister is responsible for assessing these requests, considering public interest concerns such as environmental impact and long-term use compatibility. Exemptions for when consent, that is the works permit, is needed can be made via ministerial regulation. The Policy Department, commonly referred to as VROM, is currently working on drafting this regulation. However, the absence of this regulation does not affect the validity of Article 28A itself. It means that up until the ministerial regulation is in effect, written consent is necessary for all cases that include the before-mentioned works. The Minister may withhold consent if the proposed works and activities would cause serious objections from the perspective of public interest due to irreparable damage to nature or the environment, or the current use of the land and the surrounding lands are incompatible, or irreparable infringement on the expected spatial development of the land and the surrounding area is compromised. Furthermore, important to note, the Minister may attach conditions to the consent to prevent serious objections. The written consent will be made available for public inspection in the National Gazette, starting from the first day after the date of publication for a period of 6 weeks. The written consent, commonly known as civil works permit, may only be used after A, the period for submitting an objection, appeal, or further appeal has expired without a request for provisional measuring being filed, or B, after a decision has been made on a request for provisional measure. The process for obtaining written consent for civil works should proceed simultaneously with the building permit process. This will ensure efficiency and prevent unnecessary delays for project developers or anyone constructing while maintaining necessary safeguards and responsible land use. So in short, just to clarify, everybody needs a civil works permit, from the largest development to someone building a single-room home. A civil works permit is needed. And why it's important, I think a lot of it has now focused a lot on big developments, but it's also something that everybody needs to also have. Building permit and civil works permit written consent, Article 22A of the Building Ordinance and 28A of the National Ordinance on Spatial Development. I also wish to acknowledge the procedural requirements regarding the building permits under Article 22A of the regulations governing construction in public housing in St. Martin. In accordance with Article 22A, a building permit must be put on hold until written consent has been obtained for the civil works specified in Article 28A, Paragraph 1 of the National Ordinance on Spatial Development Planning. Only after this entire process has been completed can the building permit be signed and subsequently published in the National Gazette. The written consent process for civil works permits follows a strict timeline. The Minister must decide within 60 days of the application submission, with a possible extension of 30 days. Once written consent is granted, it must be published in the National Gazette and made available for public inspection for 6 weeks. If objections or appeals are filed, these first have to be dealt with. Only after these conditions are met can the building permit be signed. Subsequently, The building permit itself must also be published in the National Gazette. Once published, assuming no objections or appeals have been filed, the building permit process is final. Grounds for denying a building permit, definition number 3. Article 22 of the National Ordinance Building Ordinance outlines the reasons under which a building permit can be denied. There are several reasons. Most of them deal with the integrity of the structure. But I think what's very important, especially for St. Martin, is articles, subsections 5 and 7. 7 states that the building plan is contrary to zoning regulations of a developmental plan or the regulations associated with an approved subdivision plan in which the land is included. In our case, we always know that there's always an issue around the zoning plan, so then that presents itself as an option. What we then look at is subsection number 5, that states that a building or part thereof, due to its location or construction method, would be unsightly, obstructive, or pose a fire hazard to the surrounding area. Article 29 of the same national ordinance gives the reasons under which an issued permit can be revoked. 1A, within 1 year from the date the permit was granted, no work has commenced or the work has been suspended for 1 year. B, during execution of the work, there is deviation from regulations established by this ordinance. And finally, a decision to revoke shall not be taken until the interested party, if his or her residence or place of stay is known, has been heard or properly summoned. 2, if the period for appeal against a decision to revoke a building permit has expired, a new permit must be applied for if the interested party still wishes to execute or continue the planned work. In that event, the documents and drawings shall be reused. And finally, on this definitions trajectory, defining official dates for permit issuance and publication, the pickup date is particularly significant as is considered the official date of issuance and initiates the 6-week statutory appeal period during which affected parties may contest the permit decision through proper legal channels. So that is, in short, once someone collects their building permit, it is stamped with a date. That date is deemed the issuance or the pickup date, and that begins the 6 weeks by which the objections can be filed. So here we are to the question, what happened? Between May and October 2024, permit publications were delayed due to internal administrative changes. This delay coincided with changes in staffing, including the absence of a technical assistant responsible for processing and publishing permit approvals. Additional gaps in staffing continuity further contributed to inconsistent publications. 2, clarification and publication process. As we stated before, permits are issued at pickup, and publication occurs only after the applicant picks up the permit. And finally, the legal implications. The 6-week appeal process starts only after pickup. It's that date on your building permit that's stamped, usually in blue. That is the date to which the appeal process actually starts. Structural challenges and past issues. I think it's important to bring this forward because what we see now is a lot of the impact of structural challenges and things that have been unaddressed over sometimes decades, and the impact it's had on having situations like this happen and what we're doing to actually address it going forward. So some of the structural challenges and past issues, there's long-standing issues in the ministry, lack of structural reforms, and need for additional staff and resources. The publication challenges we currently face in the Ministry of Rummy represent a persistent systemic issue that has plagued our operations for well over a decade. Despite multiple initiatives to address these problems, including efforts in 2022 and earlier years, full implementation of proposed improvements have consistently fallen short. This pattern of incomplete reform has created a cycle where temporary solutions are applied without addressing the fundamental structural deficiencies in our permitting system. In 2016, the Ministry of ROMI engaged VNGI, Association of Dutch Municipalities, to assist with clearing a substantial backlog of permits. While this intervention was temporarily successful in reducing the immediate caseload, it failed to establish necessary long-term structural framework to prevent recurrence. Predictably, by 2022, we found ourselves in confronting nearly identical challenges where it required another round of urgent interventions towards clearing up backlogs. This cycle clearly demonstrates that without comprehensive structural reforms that address the root cause, we will continue to experience these periodic system failures. The current backlog situation represents perhaps our most significant operational challenge, with conservative estimates indicating that it will require approximately 1 year to fully resolve the backlog with our current resources. The primary contributing factor to these delays has been consistently insufficient staffing levels, particularly in specialized evaluator positions and admin support roles that are essential to efficient permit processing. Without addressing these fundamental resource gaps, any procedural improvements will be undermined by limited capacity to implement them effectively and sustainably. Proposed solutions and the way forward. We are simultaneously enhancing transparency through significant improvements to our Lands Courant publication process. Moving forward, permit publications will include substantially more detailed information about projects, such as the number of floors or levels, the number of apartments or hotel rooms where applicable, the classification of permits as residential, commercial, or mixed use very specifically, and specific measurements relevant to the project type. Additionally, we plan to make permit information more accessible to the public by publishing it on the ministry's website along the traditional National Gazette, ensuring broader access to this information going forward. To tackle the existing backlog and improve operational efficiency, we are pursuing several parallel initiatives. We anticipate receiving comprehensive proposals from VNGI by the end of this month that would not only assist in clearing the current backlog, but also include the long-needed structural changes to mitigate further backlogs. Concurrently, we are actively recruiting several evaluators and technical assistants to increase our processing capacity. Perhaps most importantly, we are investing in digitalization efforts, including the implementation of a modern ticketing system, digital tracking compatibilities, and comprehensive document scanning, all designed to modernize our workflow and prevent future backlogs from developing. I go back in my presentation to my first slide, where I spoke about the importance of accountability. We will all make mistakes. It's important, when being accountable, to also come with solutions to avoid it happening in the future. So with that, Madam Chair, I thank you and I open the floor to all questions to members of Parliament.
Thank you, Minister Patrice Gums Jr. The members of Parliament, it's now your opportunity to ask questions. I see we already have a speaker. And just a reminder that the allotted speaking time is 20 minutes in the first round and 10 minutes in the second round. And I immediately go over to the first speaker on the topic, and that is MP Doran. MP Doran, you have the floor.
Thank you, Madam Chair Lady. Good afternoon to you. Good afternoon to my honorable colleagues, the SG, the honorable minister, his support staff, and a special good afternoon to the people of St. Martin that are tuned in or following this meeting via various means. Madam Chair, through you, I would like to say to the minister, you recently on numerous occasions mentioned the lack of publication, and you had a good few minutes talking about it just now, about building permits during the tenure of the previous administration, so to speak. You reportedly also stated that it took away the right of citizens to object while referencing the previous administration. While I personally haven't confirmed each and every one of the two allegations that you made regarding to the non-issuance of permits in the past, I would like to know, yet this point is being brought forward then, and I would like to know approximately 80% of the permits signed during your tenure went unpublished in a timely fashion for persons to, react towards it, object. My question is the following. Do you perceive this as negligence on your end? Because based on your own statement, you would agree that you took away the right of 80% of the permits of people to go against what they might want to go against or object to. So do you consider this negligence? That is the question. And if you do not find it so, then please explain to me how this can be perceived in your eyes, if you do not consider it negligence.
MP?
Through you. Through you, Madam Chair. Through you, Madam Chair. Can you explain why there are significant delays in the building permits? I heard a point brought forward, but then it makes me think that if you're aware from May, June, July, October, all these months, that there were no permits being published, what was done about it? Because during that same period, I could hear the minister ranting in different press briefings, through you, Madam Chair, about other permits not being published allegedly. So I would like some clarity on that point. Because I think that if we are bringing points forward to the public, we have to call a spade and keep things above table at all times. Madam Chair, through you, the famous Villavin hypocrisy in decision-making, in my humble opinion. Through you, Madam Chair. At the event at Villavin, you stood in front of everyone, Minister, and proudly declared the government's commitment to fully support this project and that you are on board with this project. But seemingly, when the pressure was put on you, suddenly you changed your tune, as is customary throughout your time in office, and you quickly started pointing fingers, stating, oh, the permit was issued by the previous administration, and you need to conduct an environmental impact study. I didn't remember you bigging up the previous administration during the wine and dine at Villavin. So how come when it becomes an issue, it's the previous administration, which ties into this quote that you started with, actually? Madam Chair, I would like to know, and I would like to bring it forward, because, sometimes people talk, but I would like to play this for the people to hear.
Which you have here, your commitment to Martin, really much appreciated. You have the government's support. We see this as a partnership, and we look forward.
A partnership, Madam Chair. So how is it possible that yesterday you're in a partnership with these individuals, yet knowing that an environmental impact study is required based on your assessment, but switch on them the next day? So I would like some clarity on that point, because it's quite confusing for the public. And when I'm also asked questions as a previous minister, I'm also left with a mouthful thunder and cannot respond, because it is just mind-blowing to me. Through you, Madam Chair, Minister, you have criticized previous ministers for their handling of building permits. Yet, as I mentioned, you fully supported the Villavin project. If you truly believe that this permit was wrongfully issued, why haven't you revoked it? Through you, Madam Chair, why haven't you revoked it? Or is it only a matter of revoking things or trying to revoke things when pressure is applied? Madam Chair, through you, is it fair to say that your approach to decision-making is not based on fact and legal standing, but rather on who is putting the pressure at the moment? If not, how do you explain your back and forth positions on these different projects? Madam Chair, when it comes to the classification of building permits, I heard some quite alarming statements from the minister, so I would like some clarity on that. You stated that the previous ministers wrongfully approved commercial projects under residential zoning. However, when banks finance these projects, they classify them as residential properties. Can you explain why banks, which assess risk and compliance, consider them residential, but the government does not. I know that this is maybe has been a practice for years, so maybe some clarity can be put forward where that is concerned. And I would like to know, through you, Madam Chair, who misclassified this permit in concern, the big permit that's in the newspaper that has been a topic of discussion for the last 2 weeks? Who misclassified it? Please give some clarity on this. I saw the minister give an explanation on what is residential and commercial and properties as per law, but I also heard the minister mention, through you, Madam Chair, primarily considered. So that's not saying 100%. So if I have a 100-room condominium project, 100 rooms, let's say 150 rooms where persons reside, condos, no hotel, and we have a lobby where they're selling drinks downstairs. Is that considered mixed? Is that considered residential? What would the classification then be of the ministry? And what has it been over the last, let's say, 5 years or 10 years, if we're going to go back for context sake? And Madam Chair, I would like to know if the minister can explain to the members of Parliament and by extension the people of St. Martin, if it is so, why it's so, that under your administration, permits have been issued under the so-called same misclassifications when we talk about multi-home condominiums. And if so, how can you justify that, or how did you justify that during your decision-making? Madam Chair, through you, I've realized that every time controversy arises, the minister points fingers at the previous administration. I'm asking you now, can you tell the people of St. Martin of the major decisions that you yourself have undertaken without blaming your predecessor? So which major decisions have you taken without blaming the previous administration or previous administrations? In my humble opinion, Madam Chair, the handling of matters over the last couple of months strongly suggests that the minister is not in control of the ministry, but simply reacting to outside influences that dictate. Do you believe, through you, Madam Chair, you are appointed to lead or to deflect blame and point fingers every time an issue arises? It wasn't me, it wasn't me, it wasn't me. That is a question, Madam Chair. The latter, in my humble opinion, is not getting us anywhere. During my tenure, and I want to make this clear, during my tenure, as far as I can recall, I've never overturned a negative advice regarding a building permit and make it positive. Ever, 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 ever. So I would like for the minister to also give an indication, have you ever overturned a negative advice from the department and make it positive? Because I depended heavily on the department staff. Minister, through you, Madam Chair, are you then saying, upon the staff who have relied heavily on, who majority are still there that you are currently relying on, things went wrong or they did a bad job for all these years in ill advising, given the recent media blitz and the different press releases that you released in terms of building permits in this case? Minister, through you, Madam Chair, I read something in an article a couple days ago, or yesterday, if I'm not mistaken, and it had me very concerned, where you stated that for the first 3 years in office, you will focus on investigations and you will execute things in the last year. Madam Chair, according to me, the minister is not a detective. So when you talk about investigation for 3 years, what are you investigating really? Because VRUMI is a very fast-paced ministry, always on the move. So I'm trying to understand, how are we going to hold back on plans, hold back on execution, hold back on every single thing that has to do or influence the livelihood of others to do investigation while not executing anything? Can you clarify what you meant by this, Minister, through you, Madam Chair? With regards to infrastructure and permits approvals, I have these following questions. Minister, through you, Madam Chair, since taking up office, it has been noted that you've signed a large-scale building permits and blocking others. So I'm trying to understand the consistency in your way or the manner in which you execute your task. Could you provide a clear explanation as to what criteria you've used to which developments yes and other developments no? For example, the high-rise that you approve in Maho, where everyone else you are telling no. Given the recent issues in GB, through you, Madam Chair, can you provide an update on any communication between your ministry and GB when signing off building permits? Not only an update, can you provide a document, any document, what is used through you, Madam Chair, to say, hey, GB, I'm signing this. Do you give your green light? Do you give your approval? Because according to me, well, not according to me, definitely the budget 2025 hasn't been published. There's no new generators at GB yet. That is for sure. So the capacity load hasn't changed. We have an interim, which is a short-term solution with the backup generators. So I would like to know, are you then putting the force of these new buildings that you sign, especially this high-rise in particular, on the dependency of the grid that is already fragile? Through you, Madam Chair, if the building permits are in accordance with the ordinance, what legal grounds does the ministry have to deny them? Again, I repeat, if a building permit arrives on your desk, Minister, with all the legal grounds in accordance with the building ordinance, what tools do you have to deny a building permit in that case? Are you denying building permits based on personal or party sentiments rather than legal guidelines? And if so, what do you believe can be the repercussions of such? Through you, Madam Chair, are you currently implementing any policies that will restrict large-scale developments in the future? If so, can you please share this with Parliament? I can recall, through you, Madam Chair, maybe a month or two ago, where the minister said tough decisions are going to be made and things are going to change. I haven't seen anything change, and I would like to know if this is an internal document using this to assess applications, or this is something that's going to come out to the public. Or it's just personal opinion, oh, I like this, I like that, I know this person, I don't know that person. I would like some clarity on that, Madam Chair. The next point I would like to bring across for clarity through you, are you currently in the process to implement some sort of building stop based on your statement with the investigations and how things were done in the past? Are you of the opinion or in the thinking, is the ministry busy trying to put together some sort of building stop for the next 3 years? Through you, Madam Chair, I would like to know from the minister, are you able to definitely state that every permit that has been approved so far fully aligns with the law and does not contradict any standards that you have criticized in the past? So that's a question. Madam Chair, today, I read in the Good Daily Herald, Duran issued a residential permit for 18-story hotel against policy advice. Now, I would like to know, was this article submitted by the minister? Are the contents in this article contents from the ministry? That is a question. Minister, through you, Madam Chair, I would like to know, because a lot of reference is being made on zoning. Can zoning be used, although there's no legal basis? So legally, I'm talking solely legally, I'm not talking common practice. Can the zoning be used, although there's no legal basis? And I would like to know, can the minister assess anything outside of the building ordinance and parking standards? Based on my recollection, the drawings of that project indicated 2 sublevels and therefore was evaluated as part of the entire application, so the foundation. So when there's talk about a civil works permit, it makes me wonder if this will now supersede a foundation that is in the permit already, that is already granted, or should I see this as 2 separate things? The reason I ask this, Madam Chair, is because based on what the minister said, since the reinstatement of Article 28A, which I reinstated back in 2021 for the record, the ministry and the departments have been functioning totally wrong for the last 4 years. And ill-advising. If you're saying, Madam Chair, through you, that even if you're building a home, a prerequisite is needed for a civil works permit. And if so, have you then started this since last week or 2 weeks ago, whenever you discovered this? That is a question. I would also like to know, based on the permit in question that we are talking about, if a civil works permit will be required when it comes to building a foundation. So forget this building permit. Let's talk in general. Is a civil works permit required when building a foundation? Through you, Madam Chair. And regarding the whole Westview project, are the setbacks in accordance with the building ordinance? I would like to know. And did the permits department and the VROM department have conflicting advices on this same permit? What is the Department of Permit stance understanding this matter based on what I read in the article, which I'm assuming was produced by the minister? If yes, was this the first time that departments within the ministry differ from opinion? And what decision should be made based on the minister's opinion if 2 departments are having conflicting advices, where in this case we're discussing a permit where the permit department leads in that regard? You know, one of my main concerns I've had with this whole situation, Madam Chair, is that whenever it comes to our local people, whether pooling together or trying to accomplish greatness, there's always this great energy to attack. Now, I remember this Westview project coming online, and it took 2 years. It took 2 years to get, I'm talking about application, processes, back and forth, denial, come back, approval, come back, adjust the parking, adjust the spacing, the setbacks, all these different things happened. It took 2 years. But based on the media blitz, through you, Madam Chair, of the minister, it will give a perception that me and Mr. Lake and other locals went under a tree somewhere and signed a building permit and nobody knows, and it's a whole secrecy thing. So for me, Madam Chair, I would like some clarity on that point. Why is it that when it comes to our locals, there's all this energy to take them out? But others, like for example, the high-rise at Maho, that can be granted with a smile, with a heavy heart. Madam Chair, I don't believe in classes. I don't believe in the have and the have-not. I believe in fairness and justice. So I hope that the minister would ease up on the rampage in trying to destroy the dreams of these local professionals. And I hold my other questions for the second round. Thank you.
Thank you, MP Doran. The next speaker is MP Lewis. MP Lewis, you have the floor.
Good afternoon, Madam Chair. Good afternoon to the honorable members of Parliament. Good afternoon, Minister and your support staff, and the listening and viewing public and those in the tribune. Minister, through you, Madam Chair, I would like to read and reiterate some of the things that MP Duran just mentioned. This is not about making quick decisions for political mileage. My goal is to investigate what needs to change and how we are going to change it, and then execute those changes in a structured way. So these here, I have no problem with. But the first 3 years of this governing term are for investigating and restructuring. The last year will be for execution. This approach may take longer, but it's the only way to ensure lasting improvements. Minister Gomes, through you, Madam Chair, we are a country that had one stable government for 4 years. And I need you to explain to me, what do you really mean by that statement in this article that I saw on one of the internet, I don't know if it's a blog, you consider it as a newspaper, because the people in this country is suffering. So I would like you to clarify, if you're telling me that if one applies for a mortgage and is granted that mortgage to buy a piece of land and would like to build, that we wouldn't get any building permits for 3 years, and that this would be executed on the last year? Many have made statements when justice workers, for example, had get some money from one of the previous ministers just before election, well, now MP Duran, and we claimed at that time that this was for political mileage. But this is politics. And politics in a country, we are supposed to serve the people and only the people. So I need you to clarify exactly what you meant by that statement, and that it would be ratified as soon as possible, because you're telling me that this government indeed will last for 4 years, and you're also telling me basically on your second term in office. So I think you're predicting that you will be in office after 4 years to continue the work that you are now doing. I will go on, Minister, to you, Madam Chair, regarding the 10-story development in Maho. Some you may already hear from MP Duran, but I will not deviate from my questions that was already planned. Can you provide a detailed breakdown of the approval process for this project, including which specific policies and regulations were taken into consideration? What assessments were conducted to ensure that this development will not negatively impact the airport's radar system or surrounding the infrastructure? Were any environmental impact studies conducted before granting this permit? And if so, what were the findings? I'm now going to hit a topic on general infrastructure and development policies. What measures are in place to ensure that large-scale developments do not overburden the island's infrastructure, including roads, utilities, and public services? How does your ministry balance economic development with environmental conservation when issuing permits? What steps are being taken to enhance public participation in the decision-making process for major development projects? What is expected effects on price of property once the zoning plan goes into effect, especially seeing that the most hillside land will be zoned for nature and not for building? What are the plans of the ministry to reduce the high cost first-time buyers encounter when trying to purchase property? What are the plans of the ministry to support the agriculture sector? If it was not in your presentation already, I would like that answer. What is the status of the dump? We have been told for years now that it's almost at its capacity. What is being done to reduce the flow of the garbage that reaches the landfill? Personally, I drove down Mount William Hill today. It looks clean, but I started to imagine, how is it possible that, I know it's not you, but we all live in this country. That was our Great Salt Pond. That hill within the pond, I just don't understand it. I don't understand how the process became for it to be erected. And I need to know what we are planning to do with this landfill. It's an eyesore. Come on, we have tourists coming to this country. We have people driving through Pond Island, health issues, etc. What are we going to do with the dump? Would it be possible to get a breakdown of how much garbage removed from cruise ships for the past year? You can also expand to ask if the trash is sorted. What type of trash? Are we being paid for accepting the trash? Who oversees picking up and dropping the trash? Ask how many buildings, I'm asking, and civil work permits are currently being evaluated? How long have they been in the evaluation phase? And what is the cause of the delay? Will there be financial ramifications if government does not meet the 1-month requirement to respond to building permit applications? As I know in other ministries, especially the ministry that I once managed, when someone applied for a residence permit and the minister does not answer within 4 months, the minister can be taken to court based on fictive refusal, because no answer is an answer. So I would like to know through you, Madam Chair, what are the legal ramifications that the minister can face or the ministry can face when someone applies for a building permit and does not receive an answer from the minister or a negative response from the minister? Is ROMI facing any current litigations for the past year? If so, can I get a breakdown? Can it be presented? Phillipsburg is also supposed to be one of our touristic areas. Phillipsburg is already dead. This is also for the Minister of TIAT. But also we have facilities in Phillipsburg that does not work. And one is the public bathroom, which is located just behind the Parliament building. And I have received information that this information have reached your office. I stand corrected if it was not, but the bathroom facility is in a deplorable state, and I would like to know how fast can you, Minister, through you, Madam Chair, have this bathroom situation be fixed as the tourists and the other individuals that is using our beautiful Phillipsburg can have a decent bathroom, a public bathroom, or restroom to do what they have to do. With that said, Madam Chair, I thank you, and I wait the answers to my questions from the Minister.
Thank you, MP Lewis. Members of Parliament, are there any other members who wish to speak on the topic? That does not appear to be the case. So we actually MP Viren is signing the speakers list. I await his signature to allow him to take the floor. And while he's doing that, members of Parliament, it's a public meeting, so the lines in terms of the topic to be addressed are a little, I wouldn't say strict, but you know, you got to stick to the topic. If it's another kind of meeting, of course, we can broaden the topic somewhat, but in the public meetings, we stick to the request, which is about the delayed publication of building permits and ensuring legal compliance and procedural clarity. So just that, just a reminder to the members of Parliament. And with that, MP Viren, you have the floor.
Thank you, Madam Chair. Good afternoon to the Minister and to all tuning in, my colleagues. Through you, Madam Chair, I'll also leave my comments for the second round of this public meeting. Thank you very much.
Thank you, MP Kotai. Members of Parliament, I will allow those of you who wish to speak the opportunity to sign or at least indicate that you would like to speak, then I can await your arrival to sign the speakers list. It's a must that the speakers list is signed for the speakers because, of course, we have to take into account if you don't speak in the first round, you can't speak in the second round. So a listing needs to be kept of the speakers. And with that, again, brief elucidation, I give the floor to MP Veronica Janssen-Webster. MP Janssen, you have the floor.
Thank you, Madam Chair. Good afternoon to my fellow colleagues. Good afternoon to the viewers, and welcome to the Minister of Romy and his support staff. And good afternoon to those viewing here in the Tribune and at home. I just have some questions about the numbers as well, and also about the process, because I wanted to know how many building permits were approved in that period from May to what was it, November, as you had presented, and then so how many were there, and also you mentioned that the process starts for objection once it's picked up, and I wanted to know if the person who was not there to send through the building permits to be published, if that is the same person who calls and asks for the permits to be picked up. And so my question then, through you, Madam Chair, to the Minister is how long on average does it take, or did it take in that period for a building permit to be picked up? I also, I took note of your final words too, Minister, through you, Madam Chair, where you mentioned that we all make mistakes. I agree, we do all make mistakes. I also agree that we don't always see eye to eye, and this more comes from the previous meeting that we had this morning where the colleague MP made a stance on casinos, and it stood out for me, and I mention it now because it has to do also with we all make mistakes, but we also don't always, we are not always on the same page. And so I leave the rest of my questions for the second round, but if I can just get those numbers, please. Thank you, Madam Chair.
Thank you, MP Veronica Janssen-Webster. We have MP Peterson signing to speak. MP Peterson, you have the floor.
Thank you, Madam Chair. Thank you once again, Chair Lady. Good afternoon to yourself, Minister, to your support staff, to the SG, the Secretariat, and to everybody else tuned in. Madam Chair, I would first of all like to thank the Minister for coming to Parliament with what I believe was a haphazard political tactic to call an urgent public meeting. At the start of the meeting, an MP interrupted the Minister for having a presentation, while this morning the Minister of Teyat was criticized for not having one. But you see, Madam Chair, if you as an MP request an urgent public meeting, then you should see nothing wrong with the Minister actually bringing a presentation forward on that same topic that you deem to find so important. But you see, when the topic is not really about informing the people of the process, then you're going to get these miscommunications. So in light of transparency, Madam Chair, thank you, Minister, once again for clarifying some questions that have been lingering in the public for an amount of years. Minister, to you, I understand, of course, of this administrative issue that happened with the publication of permits, and I believe everybody read your article on it. So I don't think that the topic that the meeting was called for is actually an issue that's pretty much black and white, although I did hear a sort of a question asked to you that kind of you can see as a little trap. But you see, I also heard about the minister today going to an event, but I want to know what that has to do with the actual process and how that project came about. Because to me, Madam Chair, at this point, unprofessionalism and reach is astounding, but not surprised. Because let me make it clear to the people of St. Martin, to you, Madam Chair. It doesn't matter if we as government support the project or not. The law and the decision-making needs to be governed by good governance, period. So it doesn't matter who likes the project or not, the law still needs to be followed. And if studies need to be conducted, it still needs to happen. Minister, if I'm not mistaken, since March 2021, a civil works permit is needed for all civil works, so including septic and excavation. In light of this, I want to ask you if this was obtained for the same Westview project that is currently on the front page of the Daily Herald for a couple of days. Because I think these things need to be addressed publicly as well, Madam Chair. When a clear draft zoning plan and policy advices are just ignored with no clear motivation as to how, that actually result in damage not only to the environment, but to the people of St. Martin. Too often we hear ministers abuse of their department heads, either silently forcing them to advise positively on projects or vilifying them when they refuse to. I should know, I've been a victim of that. But the fact of the matter is, Madam Chair, a minister cannot hide behind their department's advice, especially, Madam Chair, when there is no clear management agreement as per Article 8 of the LEOL. If you don't have a clear management agreement with your department head that basically regulates in which differences of opinion, how do you go about it, then you cannot hide behind the either positive advice or the negative advice when an approved development actually results in damage to the environment and to the public. No, this still falls under your responsibility as minister. Jouw ministeriële verantwoordelijkheid. So you see, Madam Chair, we as politicians, we like to think that we can fool the people. But the fact is that we as politicians cannot hide behind civil servants. So, Minister, as per the questions that you were asked by an MP before me about who classified the permit as residential, your answer should be the name of a minister and not of a civil servant. But you see, Madam Chair, from a negative advice can always be deviated. That is a prerogative of the minister. But you do also have to follow the law and adhere to the motiveringsbeginsel when you do. Something that I have not seen done by the previous administration, regardless of negative advices that I have seen with my own eyes. Take the objection committee, for example, for the Beacon Hill project, whose conclusion was that the objections were justified. And what happened to those objections? Nothing. And here, Madam Chair, is where it brings me to my next point, which is, to my opinion, a critical one. Because I've heard that the current minister is criticizing too much about what happened in the last administrations. But Madam Chair, I was also the chief of staff in that ministry. And you know what? What the minister said, that's putting it lightly. To jump in front of the minister actually with his answering, the building that was approved in Point Peter read by yourself, Minister, to you, Madam Chair. Why was such a tall building allowed? Because the draft zoning plan in that specific area allows a height of 30 meters maximum with a density of 40%. This is currently in our satellite system and the draft zoning system. The previous minister knows that this information is easily accessible through GIS, I assume. On that same note, Madam Chair, this so-called Westview project that is in the media, the area on which that project is projected to come, the maximum allowed height by that same draft zoning plan is a maximum of 10 meters with the same density of 40% allowed. So, Madam Chair, the proof is literally in the paperwork. On one hand, you have a minister that approves a permit that gets the positive advice from not only the permits department, but also the policy department telling him that this is okay. And then you have another minister on one hand who, despite his policy department telling him that this might be damaging to the environment and it is not a positive advice, still decides to approve it with no motivating. It is simply a matter of moral and ethics, Madam Chair. It is not rocket science. As I said this morning, Madam Chair, hypocrisy is going to be the word of the day because you cannot make this up. But the people of St. Martin are waking up, Madam Chair. And we are here to continue to make noise and hold those accountable who put St. Martin in all of these legal predicaments to begin with. So, Minister, through you, after all of these investigations, I can only ask you, what is the Council of Ministers going to do about it? What are we going to start holding previous ministers whose responsibility these things are by law accountable? When are you going to start taking them to court? for the damages suffered by the people of St. Martin by pure negligence in active decision-making rather than some administrative issue. Also, Madam Chair, through you, I want to ask the Minister about a question that I had before concerning the issues of land, in which a clear conflict of interest was circumvented by a then minister mandating another minister to sign on his behalf, while it was made clear that this had to go to COM. Minister, can you inform that this was indeed a COM decision, and if not, what are the next steps forward towards accountability for that? You see, Madam Chair, to close off, when politicians hide behind loopholes in the law, then they become dangerous. When politicians do questionable things, and when asked about it, their answer is simply, but did I do anything illegal? Then you have to read between the lines, Madam Chair, because that person has no intention on fixing their moral compass, but always will find a way to justify wrongdoings, rather than grabbing a mirror and doing some self-reflection. But we're here to set a higher standards, not only for politicians, but the whole island, Samat. So thank you, Madam Chair, and I'll await the other MPs and see what round 2 has in store. Thank you, Madam Chair.
Thank you, MP Peterson. The next speaker on the speakers list is MP Irian. MP Irian, I give you the floor.
Good afternoon, Madam Chair. Madam Chair, earlier on during the other meeting, I had a few comments in the meetings before that also, and I said, I realize that certain MPs have particular energy only when it comes to particular laws and particular topics. Like for me, I could tell there's a passion for that. But I hope that the MP before me remembers all those same words when other meetings come up. Because I would also want that same accountability with the Council of Ministers for the other items that are to come. That I want the same energy, because I will be repeating the exact same words as the MP when the time comes. And Madam Chair, also, the MP mentioned this 3 times. I guess he's not getting the attention that he wants, so I'll make it very clear now. The MP mentioned a minister, referring to myself, signing a MBA for another minister, and he's right. He is right. Because when we came in, former Minister Chris Waverd at a time is the one that actually signed off on the land that he's referring to, not our administration.
MP Irian, your indulgence, please, as I allow MP Peterson to make an interruption. MP Peterson.
Thank you, Madam Chair. Just to save everybody's time, what the MP is going to say is that the draft issuance was done by the then Minister Bromicus Weaver. But again, draft issuances, I have seen 100 of them come and go in the Department of Domain Affairs. The actual decision to sign it that moment, he was not minister. And that's actually what I was referring to. So to be in front of what MP is going to say now, it was indeed a draft, but the actual issuance was done by him and the other MP. Thank you, Madam Chair.
Thank you, MP Peterson. MP Irian, you may continue.
Thank you. No, I'm happy, Madam Chair, that now he decides to clarify, because every other time he does not tell the truth. So now I have to trigger it. So I'm happy that the MP decides to finally speak up. And again, it's nothing to the former minister. The minister did what he had to do, but you can't question me on why the land was given. I was not the minister then. So you would have to actually question the former MP, now MP, former minister, on why he decided to do that. But I don't see nothing wrong. If he made a decision to do it, then fine. But I'm happy again that the MP himself clarified and basically finally telling the truth, because if I didn't trigger it now, he would not have said. Minister, based on, because I started to get some questions right away from persons that are in the process of a building permit, have the building permit, or already building, and they're asking for clarity. You mentioned about the civil works permits. You said that everyone needs a civil works permit, everyone, from building a septic, whatever. Will you be requesting those entities without civil works permits to stop building officially? So put out a press release, press briefing, radio, to stop building until they have the necessary civil works permit, because that's a good bit. Will you be sending out, what the other question was? Yeah. And to be clear, will you be requesting the ones that have building permits didn't start to build as yet, have building permits, started to build already, are you going to request all of them to basically halt until they have the civil works permit based on your own statements and based on statements in the media? Because as you mentioned, it's not about big or small developers, it's about everyone. In addition to that, seeing that you have an understaffing situation or a structural under-resourced department, are you now going to send out your inspectors, because now you already have in your database every building permit that exists, all right, that does not have a civil works permit. You already mentioned now that they need one, every single one. So now the accountability is on you. The accountability is on you. So now, will you be ensuring through your inspection department to go at every location, everybody that has a building permit that does not have a civil works permit, will you make the calls and the emails to them saying, hey, please do not start any construction until you have the civil works permit? Will you be doing that? Again, because we cannot say things in the floor of Parliament, and you clearly stated, I took a picture, I love the quote about the accountability, because I don't want to hear after the fact, oh yeah, sorry, no, sorry. No, you have the opportunity now. Matter of fact, you can sit in the floor of Parliament when you come out to give your answers, but I would hope that after today, all right, by tomorrow already, actually, you already sent out those emails, you made these phone calls, because there are persons right now that are in our building, and they tell me, hey, I don't have a civil works permit, right? And since when this came, so actually the education is not there, right? So, and that's fine, but now, what I don't want is that the one in Maho don't have the civil works permit, they continue building, and you just ain't get to them as yet. Then we get be busy calling them. No, we understaffed, the inspectors ain't reached there yet. But then the one in St. Peter's, building the one-bedroom house, boom, he get hold up. The one in Miller Region, they get hold up. The one in French Quart, not French Quart, you get the point. The farmer, the speaker before me mentioned about the haves and have-nots. We don't want to continue creating that situation. So I would really want clarity on that. And if you can't answer today, please, I would hope that through your position, the government Facebook pages, whatever you have to do, that the message gets out. The structural issues that you mentioned, the understaffing, is that budgeted in 2025? So the budget 2025, have you budgeted that? And if you did, what are the consequences? We don't have a ratified budget, so you can't hire anybody, right? So how much longer can you deal with this? So, or what is the impact on your ministry by not having a ratified and published budget to be able to hire? You can't even start the process. So what is the impact on that? How long does it take, on average, for a National Gazette entry to be made? How long does that take? And Minister, when it comes to calm decisions, even those of other ministries, but that, do you see yourself or hold yourself accountable to any decision that comes out of calm? Any and every? Any decision that does not follow the law, any decision that breaks the Constitution, any decision that breaks the subsidy ordinance that, no, maybe you're proven, maybe again, you've said it already, you've made mistakes already, right? You didn't see it. Do you hold yourself accountable to those things? That'd be all, Madam Chair.
Thank you, MP Irian. I continue with the list of speakers, and I now give the floor to MP La Cruz. MP La Cruz, you have the floor.
A blessed afternoon, Madam Chair, Lady SG, the Minister and his support staff, those in the tribute, my fellow members of Parliament, and those watching on social media. Madam Chair, Lady, I'd like to shake it off a little. In here, feel a little kind of tense. But I have a couple questions for the Honorable Minister of VRAMI. And a couple days ago, I saw an article And the heading was Wally and Associates, which is owned by the St. Lucian man. This time he is asked with preparing a 3-year strategic plan. So I'm first going to comment on the heading, because I have a problem with the heading, okay? The problem with the heading that I have is I don't care where nobody from if they could do the job. But I'm going to come back to this, Madam Chair Lady, through you, is why do we need a strategic plan that costs almost $100,000 US? So I'd like the minister to explain me exactly, because how many building permits do we have now in the Housing Foundation ready to go? Do we have land for it? So if the minister could give us just a brief update on what is going on by the Housing Foundation, seeing that this is something that is extremely important on St. Martin, housing, and it is something that I did discuss and had questions about during the budget debate. So if the minister would clarify that article and explain what I did, what exactly is the idea behind it, I would be very much happy. And the rest of my questions will come after the second round. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. I continue now and I give the floor to MP York.
Thank you, Madam Chair. Once again, good afternoon to Madam Chair, to you, Madam Chair, the griffier, the Minister and the support staff, honorable colleagues, and those viewing at home. Minister, to you, Madam Chair, after taking note of your presentation, I didn't know in the beginning where, Madam Chair, where the Minister was going with the presentation, but while listening to the presentation, I found myself a bit perplexed because although very informative, I remember posing the question to the Minister a couple of months ago, hey, Minister, as chair of the Forming Committee, I would like to engage in educating the public on important topics. Do you have any topics you would like to come to Parliament to explain? I never got an answer to that. And coincidentally, a couple of weeks ago, I was, as chair of the Forming Committee, I was speaking with the third chair of the committee, MP Peterson, and we spoke on this very topic, being permits. The only thing why I said I'm a bit perplexed is that when the idea of coming to Parliament to educate the public on things that they need to know, I didn't really get any proactive answer, but the minute it's to the Minister's benefit, he's readily available to explain everything as it pertains to disseminating information. So I think moving forward, Minister, I know you had no ill intentions with your presentation, but I would also like that proactivity when it comes to outside of realms such as what we find ourselves in, that we are also open to engaging with the public and explaining and sharing information. With that being said, in your presentation, Minister, you explained a lot about different classifications as development, and even that these classifications are to be mentioned in the future National Gazette. I'm not sure if our laws recognize these classifications as yet, so I stand to be corrected. So the following question, can the Minister explain what does the building ordinance and the building code say about residential, commercial, mixed use development requests? Can the Minister explain that? There's also an article, a law, which is used as it pertains to approving and denying permits, namely Article 22. It has 8 points. I'm not going to hit all 8 points, but I will have a question about them. I'll name it, I'll read out a couple of things. So the article goes as follows, artikel 22. Een beslissing tot het verlenen van voorwaardelijke bouwvergunning of tot gehele of gedeeltelijke weigering is steeds met redenen omkleed en kan slechts gegrond zijn op één of meer van de volgende omstandigheden. So basically, the following points you can approve or deny a permit. From the 8 points, 2 points jump out at me. Now, I'm curious to know, what does the ministry have in place to actually implement these points? Because at the end of the day, we're always having the conversation about, hey, this was approved, what can be done about it, etc., why something was approved. So the following points I would like to have some clarification on. Dat het gebouw of gebouwsgedeelte wegens de ligging of wegens de bouwwijze, de omgeving ontsieren of hinderlijk, dan wel brandgevaarlijk voor de omgeving zal zijn. Basically, if the new project tends to the possibility of disfiguring the environment or the surroundings, you can deny it on such basis. But what does the ministry have in place in order to do that? Also, point 7, dat het bouwplan in strijd is met de bestemmingsvoorschriften van de ontwikkelingsplan, dan wel de voorschriften behorende bij een goedgekeurd verkabelingsplan waarin de bij aanvraag betrokken grond is begrepen. So, Minister, I'm not going to read out all 8, but I would like to have an answer on Article 22 on what, through you, Madam Chair, what the department has in place to implement or actually make use of these articles. With that being said, going back to my initial point, I find that the ministers, through you, Madam Chair, the minister's tenure up to now, I will not accuse the minister of doing nothing, because that would be disrespecting everyone else sitting on the table there today and those in the different departments. But I will say the following. I find a lot of what the minister has done to date very reactionary and not proactive. And why I say reactionary, from the smallest of things like this presentation, is a reactionary something when it could have been proactive, we could have done it before. There are a couple examples named today. I will not go back on them, but every article I've seen on them has been a reactionary response or a reactionary decision. And I'm not going to lie, the minister has branded himself as the minister, through you, Madam Chair, that's willing to make the unpopular decisions. But why do these decisions or intent to make them come after public scrutiny? All right? Because when the minister, or when this staff took office, I remember the first couple of months they said, through you, Madam Chair, that they were doing investigations then. So if you were doing investigations then, I would only assume that some of these problems were already identified then. Why wait until it hits the Daily Herald to actually say or do something about them? And, to be fair, the construction projects that we are talking about today, that has been in the news as of the last couple of weeks, were these known by this administration prior to them being published in the Daily Herald? And if so, what were the moves, actions taken then compared to those now? I say reactionary and not proactive because, and this is something I've shared with the minister, some of his staff, and also other ministers, and I also made mention of this during the various budget debates. When ministers come to Parliament, or the ministers of this cabinet come to Parliament, we get this much of information. But when I go on Facebook, or when I read the Herald, they're given this much of information. So a lot of times, just as those at home, I see things or read things the same time they read it, while the questions are being posed in Parliament. So my question is, why are things being put out there that either is still in the infancy, in the planning phases of it, and not ready to execute? Because if we're talking about riding on, I would say, okay, let me change, different choice of words. If we're talking on political maneuvering, if we're talking about making use of the public sentiment or the public cries, if we say we're going to do A and A is not ready to be executed, why are we saying that? Perfect example, I've had many conversations, for example, with one of the staff members about it. Something I was very glad to hear, but for example, when the minister said in December that the closing of, or the investigation into illegal garages, that was something that touched me very, very much so, and I was very much looking forward to it, only to hear that the execution date is not planned as yet. You know, so these are things I'm like, okay, if we're not that far in the process, why are these things being disseminated to the public as if they are going to be done right now? To me, that is kind of playing with people's feelings. I'm not saying the minister is lying, because I know the minister is working on these things, but the timing is very, and in all fairness, is not something only of the Foreign Minister. I've made comments about this when it comes to the Minister of Finance, sharing of vehicle plan, tax plan, and the minister cannot answer any questions pertaining to the matter. Also, as chair of the Foreign Committee, the minister did grace us with his presence and had a very enlightening presentation. The presentation was very deep, and he explained, where the minister explained to you, Madam Chair, that in the next year and a half, you'll be executing things of planning for things such as zoning, erosion, tackling the erosion, the drainage issues in the hills, etc. And that's something that I'm actually looking forward to. And I've spoken to the minister a lot of times off the record. Thank you. Off the record, and those conversations were very fruitful. So only to my shock, for the minister, to you, Madam Chair, to understand my shock, when I read, and it's been exhausted up to now, but I'll say it again, the first 3 years of this governing term are for investigating and restructuring. The last year will be for execution. This approach may take longer, but that's the only way to ensure lasting improvements. Now, Minister, as much as I would like to say there's part of that excerpt that I do understand as it pertains to restructuring, two things. When I read the first 3 years of this governing term is merely for investigating and restructuring, it makes me question what is going to be executed in that moment and that period of time. Because, you know, without evaluating the past, we can't see where we're going as well. I think if we were to ask the prior administration on March 2020, when they took office, what do you have in mind for the coming 4 years? They thought they had 4 years to do and plan and to execute all the things they wanted to do and implement all the things they wanted to do. Only when reality set in, you get COVID, you have XYZ things happen, and you actually have only 1 year, 1.5 years, to do all of what you were supposed to do in 4 years. So when a statement like this is made, I almost want to ask the minister if he has a crystal ball to know what is to be expected in the coming 3 years. Because while we say, hey, we're going to put this aside or that aside, while we investigate, to me, which is, there are other entities in government apparatus that does that, that do that, while the ministry is busy investigating and restructuring, nothing is being done. At least that's the feeling I get after I'm reading this. If the minister can clarify that for me, because the conversations I've had with the minister, the presentations I've had from the minister, it directly contradicts this line. And this is why I say a lot of times, and I've told this to another minister as well, things that are said should not be in the heat of the moment. Although this may seem like the smartest thing to say, it's not. And it should not be something that just because we know some people want to hear it, it's something we have to say, because sometimes the truth is different than the reality we live in. We cannot wait 3 years to tackle the erosion problem. We cannot wait 3 years to tackle the drainage problem. And although I understand sometimes you need to understand what went wrong to understand what you're going to do to fix it, the ministry in which the minister took, as stated earlier, is a ministry that needs ad hoc plans and ad hoc implementations and ad hoc executions sometimes. And I understand the minister does not want to continue trends of old, but some things still have to get done. With that being said, I've seen many articles over the last couple of months, and I'm only anticipating to see more moving forward, but I would like to take the the question mark out of the room. So every time there's reference to advices not being followed and permits being granted. In all transparency and fairness, I would like the Minister to provide Parliament with these advices where advice was given and advice was not followed for current projects and future projects of which the Ministry is aware of. I think it's only fair for the viewing public and this House to understand what is to come, and if it's to come, what caused it, or what decisions led to what, or what advices led to which decisions, whether it be good, bad, or indifferent. Fair is fair. In the article as well, the Minister pointed out that hasty decision-making leads to lawsuits and jail time. I don't disagree, but I would like to add one thing to that as well. Hasty decision-making also leads to bad spending, or misuse of finances. And in all fairness, the prior administration, in particular Vromi, didn't always make the best decisions where spending is concerned. One of them is something that, although small, is an example of what I'm trying to elucidate to everyone today. So here, I have a picture of the good and hard workers, workers of Vromi, painting the zebras that we have today. In this picture, what you will see is a bucket of paint, a roller, a stick, and workers. After outlining it, they're rolling it on the road. This is the manner in which you paint a house, not a road. Right? So this mistake was already done by the prior administration, namely on the Bush Road. Right? And no one really understood when certain things were said then, but we see the results now. Namely, you paint it on like a house on a road, within 3 weeks to a month, it's going to be gone. And we can see that now on the Bush Road. So my question is, when the minister took office, and I could bring up more examples. I don't want to do that because I don't want this conversation to go somewhere where it's not intended to. But I'm seeing the same. We're supposed to learn from mistakes or take mistakes as learning moments, right? And I'm seeing this administration doing the opposite of what they say, this minister, doing the opposite sometimes than what he said in the beginning, which is learning from past mistakes. Because the same way we hear painting on roads, painting on lines, we're also still paving 4 centimeters of asphalt. And, you know, I didn't go into details then because I confronted the minister and I asked questions about it. The minister ensured me that he put on 12 centimeters and the 12 went back down to 5, et cetera, et cetera, et cetera. But I would like to remind the minister of my background. I would like to remind the minister of the company I worked for before entering this house. And I'll be frank with the minister. Minister, I know the person making the asphalt. I know the person ordering the asphalt. I know the person raking the asphalt. I know the person on top of the machine. I know the person behind the machine. I know the person signing the contracts for them because I worked with all of them. So when I say, Minister, why are you still doing things that were done previously that you say you wouldn't have done, and you say otherwise, you're forcing me to go deeper into it, and I don't want to do that. So my question is, going back on why this meeting was initially called, if you say you're going to do something in a particular way, why is the opposite being done? So if you're talking about transparency, why 2 weeks after pointing out something that the minister, the former minister did wrong, 8 out of the 10 things you were doing on a topic was wrong as well, the exact same thing what the Prime Minister was doing. And although I understand and appreciate the apology, it doesn't take away from the fact that just 2 weeks before that, fingers were being pointed at the former minister for the exact same thing. And then the explanation comes, yes, it's a staffing issue. I understand. But why did you leave out that the staffing issue didn't start yesterday? The staffing issue was not it was always an issue. And this is not me making any excuses for things of the former administration, because I would be, I'll make use of a famous word by a former MP, now minister. I would be disingenuous to stand here and act as if the minister inherited everything that was peaches and cream in Little House in the Prairie. I know that the minister has a daunting task in the Minister of Romy. I also know through conversations with the minister has good intentions and that it's always coming from a good place. But I will say to that as well, Minister, what you inherited is not easy. It doesn't have an easy, simple fix. But by accepting the job, you're saying, I can fix it. As a matter of fact, you were a minister, through you, Madam Chair, of a different ministry, and you chose to come over to Vromi, meaning the minister found, through you, Madam Chair, that he was the man for the job. So by saying that, I look at the minister as Mr. Fix-It, right? And when I give the minister critique, it's critique because I look at the minister as such and not the poor Minister Gomes that has a lot of work to do. So, Minister, the questions that are being posed to you is not to put you on the spot, but consider it tough love. Thank you for the warning. So I'll close off by saying the following. Look, at the end of the day, we can throw mud, we can talk the truth, we can ask questions, and give answers can be given. But I think sticking to what we say we're going to do will always help in situations like this, because at the end of the day, if the minister said, I was going to do X, Y, Z, and X, Y, Z is being done now, I would have no choice but to say, okay, Minister, my bad, I didn't ask the questions then. So with that being said, Madam Chair, thank you for the indulgence and the heads up.
Thank you.
But that would be the end of my contribution for today.
Thank you, MP York. I continue with the speakers, and the next speaker up is MP De Weaver. MP De Weaver, I invite you to take the floor.
Thank you, Madam Chair Lady. Good afternoon. Madam Chair, good afternoon to everyone. I'm so sorry. You know, I think it was one of my colleagues in here that said something along the lines of, if you can't convince them, confuse them. And just listening today to the discussion and just reading the articles regarding the stop order that happened in terms of a project down over the hill in Kupakoi, when we're listening to the explanations for delays in things being published, it's so much information coming at you that it kind of seems like if you can't convince them, confuse them. But what we are not realizing at the end of the day through all of this is the only people who are confused are the ones that are being disenfranchised, which is the public of St. Martin, which is the community of St. Martin. And what's unfortunate in this whole discussion is that we are talking about projects, high-end projects, high-cost projects, high-value projects, and then it seems a little bit unfair that those are getting more attention than the other ones, like a neighbor in Middle Region who knows that illegal construction is happening next to them, but then nothing happens. Or you feel like you're restricted as a business owner in town, and town is not dead. So I'm going to disagree with MP Lewis, who said town is dead. Town's not dead for the people who have businesses in it, because we're struggling with a town that is in a deplorable state, with the roads, with old stands from lampposts on the boardwalk, we're with chairs that are broken all over it, with trash that comes out at different times. So it's not dead. It's just been ignored. And if we continue ignoring it, it will be dead. But I'm getting off track. One thing I will say is that it's the first time I've actually seen the minister stand his ground with all of the confusion that is happening, with all of the information that is just so much that I don't even know where to begin to siphon off, like to sort of organize it. And what I mean by that is there's so much confusion about what's residential, what's mixed use, what's commercial. And the minister actually said in an article today about the fact that the ministry is looking for ways to potentially communicate better with the public. And literally, most of the time in all these projects, the ones with the big mouths are the ones who are living right next to it. But again, we're hearing about the bigger, high-end, high-value projects and not the projects like a neighbor in Middle Region. So what it says to me is the way of working is insufficient. The way of working is unacceptable. And while, yes, some might feel that we are reacting to things because it's coming up and it's, it's Facebook and this is all the, where we say Facebook government, people react to all the statements coming out and articles and videos and all of that. Again, we are disenfranchising the persons that have to live here. So what I would recommend to the minister, via you, Madam Chair, who also has connections with the French side, is look at how it works over there. Are people disenfranchised? Are people suffering from a lack of communication that comes from government, who is supposed to inform us and give us all the information in order for us to make an informed decision and be a good neighbor in a community with a development that might potentially disenfranchise us, make it a horrible living experience? And I'll give you an example of if we're going to be looking at ways for us to change how we communicate with the public. Like the National Gazette of printing things is insufficient. It's only when people start making their mouths loud is when we actually start to react. And if I'm going to give the minister a proper recommendation, I'll say anybody who is driving through the French side, just look at where there's a construction happening. They have a big plastic sign on it. It's called a permis de construire. You see who is building it, but there's a company or person. It tells you how much meters it's going up, how big the land is. And you know what? It gives you the information that you can go look it up later on. So look at what is happening and what works. Because a lot of the times when you hear people on the French side complaining, it's because they've been in a zone with inherited land that they can't construct on, a zone that has been declared a green zone or inconstructible. That's what you look at. So look at what we are dealing with on the side when it doesn't work. Because here it says, proposed change is notifying the public of permit requests before approval. But the whole process, when you read the article, is so confusing that I don't understand how it's available to anyone, because it's just confusing. So you know what? Put it up on the property. Make that suggestion, because everyone is asking, how is it possible that with a policy or a plan, whether it's legal or not, if this is the way, like if this works for us? But the same way that earlier on we were discussing a casino plan that was used as an internal document for a way of working, there is a plan in place, whether you want to call it a policy, there's a plan in place for a way of working. Even more than using a plan, are we going to improve the plan? Are we going to let it sit there forever like most plans are sitting? Or are we going to actually see, what can I do in this plan to actually help the people of this country have more information so that they're not disenfranchised? Because I remember being asked lately as well, what are you going to do about persons who said they were never given the opportunity to object to a certain project? Whatever happened, happened. But how do we move forward and learn from this? How are we going to improve it? So that's the challenge that I want to send over to the minister and his team. How do you fix it? How are you going to improve it? How do you make it more accessible? Since accessible is always the word of the day. How do you make it more accessible to people so that they can object? So that we don't have to be able to figure out, wait, where do I go to the National Gazette online? Because not everyone's going to do that. So change the way of working, improve the way of working, so that people will never, ever be left in the dark again and feel like they were intentionally left out because a high-end, high-value project went under the rug. It was not done in a sort of really open manner that people could object to it, and then now we're basically restricted by, we have a limited time that we can actually object to something like that. And that's pretty much it. The one other question I had is reviewing the article today that I keep referring to of ways of working for improvement. What happens after a stop order? because I did refer to other construction that's going around, that's according to neighbors that are concerned, that's happening, that's illegal. But what is their procedure? What is their procedure to make sure that they're heard? That they're, like the person in Middle Region, what is their procedure to make sure that they're heard? That if someone is constructing illegally, how do they make that accessible to persons when a whole neighborhood is not objecting to it? I just want to make things simple for the people of St. Martin that we say that we represent. Thanks, Madam Chair.
Thank you, MP De Wever. Members, we continue as I now give the floor to MP Roseberg. MP Roseberg, you have the floor.
Thank you, Madam Chair. Blessed afternoon to the Minister of Rome and his support staff. Also blessed afternoon to my colleagues and the ones still tuned in online. This presentation that I have received was for me insightful because I do believe that providing information is key, especially in regards to the procedures when it comes to permits. And seeing that a lot of people are not aware of the procedures and or stop-up plan that needs to be followed. My colleague, MP Weaver, mentioned also the objection procedures. I would like to know, through you, Madam Chair, because I haven't looked into it, but I do believe that the ministry can provide that clarity. Is this procedure anywhere mentioned? And especially, is it mentioned simplified for the public to know? If that's not the case as yet, maybe it's an interesting idea to start an informative campaign specifically in regards to this topic so that all the people of St. Martin are aware of their rights. For example, how I started Law 101, because explaining the procedures and understanding the procedures step by step is key. And then when the public understands, they also know, okay, what deadlines need to be followed and where can I find that procedure and where is it mentioned in the law? Because my other dear colleague, MP York, referred, for example, to famous Article 22, but what does that article state? And what does it mean? And why is this article so important? Other than that, my colleague MP Irian mentioned that a lot of people are not aware that they need to have a civil works permit. Has the minister, if that's the case, thought of, for the ones that are not aware, seeing that this information now has been made visible, I don't know if it is visible elsewhere, but if that's not the case, that those people will get, for example, a grace period so that they can look into, okay, now that I'm aware, a grace period will be given, because I do believe that the law needs to be accessible for everyone, and if that's not the case, how are we going to go about that? And last question, when I was walking to Parliament this afternoon, I was stopped by a community member in regards to the garbage by the parking lot where we just park that wasn't picked up as yet. So I'm not sure who's responsible for this, but if it wasn't handled as yet, if it can be handled. That's it. No 20 minutes, but
thank you, MP Roseberg. The next speaker is MP Otley. I invite MP Otley to take the floor. MP Otley, you have the floor.
Thank you, Madam Chair. Madam Chair, as I listen today, and I listen to members of opposition and coalition, one thing can be determined as issues. There is issues and serious issues within the Ministry of Romy and this policy. Members, I can't speak for them, but a lot of the tone sense uncomfortability. Since the minister started with a quote on accountability, and the minister then states that he took, through you, Madam Chair, accountability for his actions of not allowing up to 80% of permits to be objected. To what consequence? It's easy to take accountability when there's no consequence behind it. And I would say, a quote, when you don't face consequence, there are consequences to that too. Understand it very clear. So accountability and saying, my bad, sounds nice, sounds good to the media, but to what consequence? Because who is facing the consequence? Are those persons that were not able to object to whatever is in their way, whatever is obstruction, whatever is considered illegal, all of those persons were not able to object. They are facing the consequences. And I agree with my colleague. I will touch on some major projects as well. But we are here. I am here to represent everyone, including the small man, Madam Chair. We go back to the budget. I remember specifically stating, be careful with the GEBE, because Vromi department took some of the biggest cuts, including 18 million, which some was be allocated to land. St. Martin, one thing my great-grandfather said, God isn't making any more land. We have a shortage of land, a shortage of houses. We have a housing crisis. And I say this to say that this policy, I do not agree with. The fact that we are now saying persons that have registered for government land are basically erased and will be subject to reapply. That is my problem. And that I cannot, and I will not agree with. We have an issue in this country. Persons have been waiting for years and years. A bit unrelated, but still related, we go to the Housing Foundation. There are persons who have been on the waiting list from God knows when, Madam Chair. And now today, persons who have taken their time, applied to the Honorable Minister, well, the Ministry of Vromi for government land is being said, erase. Erase and start over. That I cannot and I will not agree with. Competency goes a long way. The minister, in his previous task, through you, Madam Chair, would come and elaborate with us about friend side, dot side, land, agreements. So the minister is an educated person. However, competency is something different. Because I noticed a trend through you, Madam Chair, that the minister's colleague, party member, faction leader answers majorities of the questions for the minister. I don't know if it's putting the minister in the right trajectory, but if that is the case, then he is the competent person. If that is really the case. Madam Chair, I have to be very, very careful. We have to be careful, Madam Chair. When you have a party that states someone cannot be minister because the financiers decides. Be very careful, because the financiers of the party can be developers. Is it for, I'm hearing who said it, the leader of your party said it. Is it for personal gain, interest, that we didn't want certain people to be ministers of Vromi? We have to be very careful, Madam Chair. Madam Chair, I look at the Ombudsman report, or even look at the motion of non-confidence and disapproval brought against former Minister Duran for Vineyard Heights. The fact that persons were replaced, persons who receive, I guess, MBAs, were replaced, Madam Chair, and were told to either reapply, and new persons was given the opportunity for land. And his head was on a chopping block. And I did an interruption and asked the Honorable Minister, is it not similar? And the Honorable Minister said, yes. So rule for one, rule for all. Why is this minister's head not on the chopping block today? Why? Madam Chair, we have seen settlements. I've even seen where the judge have even sent back certain cases to be handled because Vromi, for whatever reason, the minister will clarify, the honorable minister will clarify to you, Madam Chair, did not present the proper documentation or whatever may be needed for a court case. And I saw something very interesting, Madam Chair, in 2014, when a court case was lost by the then Minister Maurice Lake. The DP faction had an article and said, and this is so true, and if we listen to 2014 to 2025, we have the same issues today. When we lose court cases, when we settle, who will vindicate the civil servants that need their money? Who will vindicate those that cannot pay their bills? Who will vindicate the GEBE issue? Because, again, funds that are spent or are lost during a court case are funds that come from the government coffers. Madam Chair, we see projects, and I stated earlier, my faction is for development, for construction boom. We sit and we hear the Minister of Finance, Madam Chair, said that construction supported the budget. Revenues generated from construction is what kept the budget afloat. That was stated by the Honorable Minister of Finance. And now I'm seeing project being pulled back here, project being pulled back there, but rule for one, rule for all. And I will say again, maybe you can provide clarity. Why are these projects being stopped for environmental reason, environmental study, impact study, and Maho was allowed? Not only a land extension, but to build. And then we see today in the newspaper, the minister, I think it's Westview, or in an article, the minister halts Westview. And then when I read an article yesterday, Ombudsman, minister to answer Ombudsman about Westview. So is the action because of the media? Is the action responsive? And then when you do a little more research, you understand the reasoning, not the reasoning, you understand who is behind the Westview, and we have locals. Locals. Now, not because it's local don't mean you don't work and operate within the realms of the law. But certain decisions should not be boosted based on media sensation. Madam Chair, through you to the Honorable Minister of Vromi. I saw an article, but I would like to know from your person, through you, Madam Chair, is it indeed factual, or was it indeed said by your person that executions would only be able to happen on the 4th year? I want to hear it from the minister himself. Executions. Because if that is the case, I want you to realize, through you, Madam Chair, how important your position is to the growth of this country. Very important. And also included in your portfolio, based on certain articles of incorporations, GEBE should still be a factor under your person. And the reason I go through this, Madam Chair, is because we have the halting of many major projects, and we need to intertwine the capacity with GB. So is it that execution is going to be within the next 3 to 4 years, because that's when we're going to finally see the generators? There's a lot of things, through you, Madam Chair, to the Honorable Minister of Vromi, I call low-hanging fruit, that I would like to see done, that we could see done. So that's why I asked, because I refuse to believe that the minister is going to say for 3 years he can't do nothing. I refuse to believe that. Honorable Madam Chair, through you, to the Honorable Minister of Vromi. would you reconsider adjusting the policy so that persons who have registered, who are in need of land, do not have to go through the entire process again? That is my big issue. Fighting for those who cannot afford to fight, because those major projects, eventually, they can hire a lawyer, they can have a court case, they can go back and forth with government, as we have seen for years. But the people who cannot, this is my opportunity to speak for them. And again, through you, Madam Chair, what are the ramifications besides the minister saying, I am sorry for those persons with 80% of permits that were not able to be objected? Because I'm pretty sure, and I heard the minister say he's receiving a lot of objections now. Is it just too late? I'll leave it right here for now, Honorable Chair, and I'll save any questions, remarks based on the answers that I receive or is received for the first round. Thank you.
Thank you, MP Otley. The next speaker up is MP Waver. MP Waver, you are invited to take the floor.
Thank you, Madam Chair. Good afternoon, Honorable Minister, support staff, my colleagues here in Parliament. Seeing that a lot of questions have been asked today, some about the actual topic at hand, and most about anything else, and even receiving a nice plug, so I appreciate that, MP, for calling my name. I will hold my further comments to the second round. Thank you, Madam Chair.
Thank you, MP Waver. The next speaker is MP Labega. MP Labega, you have the floor.
Good afternoon, Madam Chair. Good afternoon to my fellow colleagues. Good afternoon to the Minister of Romy support staff. I would like to thank the Minister for coming to Parliament and giving that presentation. I know recently there has been a lot of newspaper articles pointing out issues with Romy, permits, classification of what's residential, what's commercial. So I found that information quite enlightening. And at the end of the day, as I say, damned if you do, damned if you don't. You know, I just want you to stay focused, continue doing what you have to do. And some MPs claim that not much is going on with the Minister of Romy or the Ministry of Romy, but at the same time, you have to out a lot of fires from the previous government. I'm not going to say that the fires are good or bad, but you do have to answer a lot of questions, whether it's court cases, whether it's the ombudsman. So you have to juggle what your plans are, as well as some of the previous obstacles, I would say. So I will encourage everybody, especially the government who was there, the last administration, to lend you a hand, to give you advice if you need it, because they were there when some of these things transpired, and for all of us to work together for the betterment of St. Martin. I look forward to your answering other questions from my fellow colleagues, and I'll reserve the rest of my questions for the second round. Thank you.
Thank you, MP Labega. Members of Parliament, we have come to the end. Yes, indeed. We have come to the end, Minister, of the questions in this round. And Minister, can you immediately respond to how you propose to provide answers to Parliament? And with that, I mean, of course, when you could come back and respond to the questions as posed. I would ask you to please try and do that as soon as you can. And again, if there are issues that you really have to research, those can be, that can be indicated to Parliament. At least we can get some of the pressing issues out of the way by responding to the questions. So, Minister, from you, your proposal.
Thank you, Madam Chair. With your indulgence, if I can get 2 minutes just to caucus with the team,
sure.
And then we can read.
We will adjourn for 3 minutes, and then we'll come back, and the Minister will let us know when we can continue with the meeting because, of course, that depends on when the minister can provide the answers. Meeting adjourned for 3 minutes. Members of Parliament, members of Parliament, members of Parliament, we are ready to reconvene after a brief adjournment following the questions by members of Parliament on the topic relating to permits, etc. Here with the Minister of Romi, who of course took note of the questions, and we adjourned briefly to reach an understanding as to the continuation of this meeting, in which the Minister will be back to present the answers to the questions posed by members of Parliament. So I would give the Minister the floor right now to basically respond to that question in terms of the continuation of this meeting. Minister, you have the floor.
Thank you, Madam Chair. With your indulgence, we have gone over our calendars very thoroughly, and the only earliest opportunity we have is Wednesday the 26th, anytime after 12:30. Unfortunately, we have quite a lot to well understand the urgency of this meeting. We do have a number of questions that require quite a lot of scope sort of reshuffling to get properly answered, as well as some of the things that we cannot, unfortunately, postpone, which has to do a lot with some other pending projects we're currently working on, particularly regarding some of the questions we have posed by some of the MPs, and they involve incoming delegations. So unfortunately, the earliest time we do have is 26th of March. If not 26th of March, we have the 28th. So then we can discuss that, but that's the earliest that we currently have in our scheduling.
Thank you, Minister. We have taken note, and with that I mean that along with your office, the Secretary General of Parliament will schedule the meeting in accordance with your request for the 26th or the 28th, and that meeting will be scheduled and communicated to the members of Parliament as soon as we have confirmed that. So with that, Minister and support staff, members of Parliament, all tuned in to this meeting, I want to thank you for your participation. If it was that you were tuned in, for your interest, Minister, thank you for your presentation before we got started with the questions. And I will now adjourn this meeting until further notice. As we have understood, that will be either the 26th or the 28th of March. So thank you, and this meeting is hereby adjourned. Meeting adjourned.